Welcome to our fourth webinar in the Inventors Patent Academy series. We're so glad you've joined us for this discussion about how to build your innovation support network with our guests, Erin Kelly, Paul Hawley, and Mark Milaski. In today's webinar is presented by Invent Together, an alliance focused on expanding participation in inventing and patenting, particularly addressing diversity gaps, especially for women and minorities. Closing these gaps could quadruple inventors, boost GDP, and lead to exciting inventions. Invent Together works through research, public awareness, best practices, policy advocacy, and inventor education, including the Inventors Patent Academy, or TIPA. Launched with Qualcomm in 2022, TIPA offers free online patent education specifically designed for underrepresented inventors. It tackles the challenges faced by underrepresented groups and offers tools to overcome them. Over 2,700 students have enrolled in TIPA and is being adopted by colleges and universities, including HBCUs, HSIs, and community colleges. I'd like to introduce you to our esteemed panelists for today's discussion. Erin Kelly is the founder of Hexalign, a consulting firm at the intersection of equity, diversity, and inclusion and STEM commercialization, and the equity, diversity, and inclusion subject matter expert for the Inventors Patent Academy. Hexalign's two service lines serve minoritized innovators directly through education and training programs and indirectly through implementing equitable and inclusive organizational change for the gatekeeper organizations in the innovation and entrepreneurship ecosystem. Her expertise is in strategy, program development, instructional design, bias mitigation, and process analysis and improvement as a researcher, practitioner, and policymaker. She previously worked at IBM as a senior change in learning consultant and at the National Women's Business Council as director of research and policy. Paul Hawley is an experienced attorney who has worked at high-profile law firms such as Banner Witkoff, Foley Lautner, and focused his private practice on patent prosecution. Mr. Hawley is a graduate of the John Marshall Law School, now University of Illinois at Chicago Law School, as an Honorable Howard T. Markey Distinguished Scholar and member of the Order of John Marshall. He is currently the director of the Chicago-Kent Patent Hub. This pro bono program was launched by the United States Patent and Trademark Office in 2011. The Patent Hub, starting in 2015, is one of the 22 patent hubs around the country that originated under the America Invents Act to assist under-resourced inventors with the patent process and in securing patent protection. Mark Milaski is a registered patent attorney with intellectual property consulting. Mark also holds a mechanical engineering degree. At IPC, Mark's practice includes patents, trademarks, copyrights, trade secrets, and related intellectual property and business formation matters. He represents diverse clients, ranging from first-time investors and startups to multinational corporations. Mark is an adjunct professor at the Tulane University School of Professional Advancement, where he teaches intellectual property and entertainment law. He's also the co-founder and steering committee chair of the Ella Project's Gulf South Invents, part of the USPTO's Patent Pro Bono Program, which matches volunteer attorneys with inventors having limited resources. Please help me in welcoming our panelists. Erin, let's start with you. Can you talk about some of the resources available for our inventors? Let's unmute you real quick.
I was already with my mouse over the button. Yes, I'm happy to dive into that. So we'll get into the initiatives that are specifically helping inventors with patenting when we bring in Mark and Paul. Before that, I wanted to go into some of the business and entrepreneurship resources that are available to inventors. The Inventors Patent Academy is focused on patenting, but we know that inventors also need support with building the business for their invention. The TIPA Resource Hub features a broad selection of resources, including some of the programs I'll discuss in a moment. I encourage you to check those out as you make your way through the course. Today, I'm going to go over 5 main categories of resources: educational content, technical assistance, capital and funding, accelerator programs, and regional resources. Next slide, please. For educational content, the SBA has 2 great resources, the SBA Small Business Guide and their Ascent platform, that cover many different domains of setting up your business, thinking about your value proposition, the nuts and bolts of the legal parts of the business corporation and other relevant regulations, how to do market research, and other topics. Next slide, please. Technical assistance typically includes consulting, coaching, or training, and other services that help startups reach their goals. At its core, technical assistance is about providing knowledge, expertise, and resources to startups. The SBA has many programs that provide technical assistance. SCORE provides access to business mentors who are typically retired executives who have a wealth of experience in their fields. Small business development centers offer free, confidential, individualized advice to start, expand, or grow small businesses of all kinds. The SBA also has resources for some specific populations. Veterans Business Outreach Centers specialize in serving veterans, and women's business centers specialize in serving women. Finally, with the SBA, each state has an organization funded through the Federal and State Technology Partnership Program. These organizations provide technical assistance to support small business innovation research and small business technology transfer applicants and awardees, and I'll discuss those programs in a moment. Next slide, please. Other agencies also have resources to help innovators and entrepreneurs. The Minority Business Development Agency has MBDA business centers across the country, as well as specialty centers for federal procurement, exporting, and advanced manufacturing. The National Science Foundation has the I-Corps program, which takes inventors through a customer discovery process to help de-risk the further development of their technology. I-Corps programs are associated with universities, but some are open to members of the community at large. Finally, the National Institutes of Standards and Technology has the Manufacturing Extension Partnership. Their specialized expertise is in assisting small manufacturers. Next slide, please. For capital and funding, the SBA has several great programs. One that's particularly good for inventors is the program that I mentioned before, Small Business Innovation Research and Small Business Technology Transfer Programs. These programs grant funding to small businesses that have promising technology that line up with various government agency needs. This funding isn't a loan, so it doesn't need to be repaid and doesn't require you to give up equity in your company. The SBA also guarantees the small business investment companies, which invest in small businesses with their own funds and leverage SBA guaranteed funding. And finally, for the SBA, they also are SBA loans. Those are governed by SBA guidelines and are backed by SBA guarantees, which lowers risk and makes more funds available. The MBDA has the Capital Readiness Program, which focuses on minority and other underserved entrepreneurs. There are 43 sites nationally which offer technical assistance as well as access to capital and networks. Funding is also available from the NSF through the Partnerships for Innovation initiative. The Technology Translation Track funds small teams moving one basic research project into early technology development. Next slide, please. Accelerator programs typically offer technical assistance and access to networks in a cohort model that meets during ongoing programming. The SBA has awarded prize funding to organizations that work with underserved entrepreneurs through its Growth Accelerator Fund competition, which has awardees across the country, and you can find out where those sites are at the link on the page. The National Science Foundation also has the Convergence Accelerator, which grants funding to teams and takes them through a research and development phase and a prototyping phase. A couple of Invent Together partners also have open accelerator opportunities. VentureWell has the Ascend and Aspire programs, which prepare climate tech and medtech entrepreneurs to work with investors, bridging the gap between customer discovery and commercial launch. And the the Women in Engineering Proactive Network, or WEPAN, also has the WEPAN Accelerator, which serves women and gender nonconforming innovators of color in STEM in their entrepreneurship and commercialization journeys. Next slide, please. Finally, there are a couple of regional networks of resources. The SBA has regional innovation clusters, and the NSF has regional innovation engines. Both of these initiatives have field or industry-specific sites offering technical assistance on, for example, cybersecurity, medical, and aeronautical technology. That was a lot of information in a short amount of time. In case you weren't able to catch these links, they will be available in the TIPA Resource Hub. So let's open it up to our panelists. Welcome, Paul. Welcome, Mark. It's so great to talk with you today. Can you tell us how you got involved in patent law?
Sure, I can go first. I actually went to college for engineering, and I was an engineer for a good 2 years before I even thought about going to law school. When I did go to law school, I was doing engineering during the day and going to law school at night for several years. So it was quite a busy time for me. But at the time, I was working for a organization which was actually headed by a patent attorney, and that's when I sort of started thinking about it, got interested in patent law, got interested in the whole process, and started doing those classes at night.
What about you, Mark?
Well, thank you so much for the invite today. I'm very excited to be part of this panel and looking forward to our discussion to see how we can help the inventors learn about our programs. So when I was in high school, I ended up at an engineering magnet program. So we were all gearing up to go to school for engineering. But, you know, as you're a kid growing up, you're always supposed to have an answer for what do you want to do when you grow up? My dad's a lawyer. So I was like, well, I kind of have a little bit of a snappy personality. I should go to law school and follow in my dad's footsteps. So my answer was always, I'll be a lawyer, but I knew I was going to go to engineering school. I like playing with toys, you know, cars and things that you can build and all those kinds of things. Typical engineering and patent kind of subject matter. And so I've been talking about that throughout high school, and a medium-sized patent firm, which is now one of the bigger ones in the country, reached out to the school and was like, hey, we'd like to give a scholarship to a student that's interested in possibly going to law school after engineering school, which could lead to a career in patent law. Do you have anybody that might fit that mold? And they're like, well, Mark sounds like the right candidate for that. So the next thing I knew, I was selected for that. And then they're like, hey, if you want to come up here and work during the summers while you're in college, we'd love to have you. So I'm pushing the file cart around, making coffee and filing papers at the impressionable age of 18, and I just fell in love with it. So kind of never looked back, and here I am doing it every day, and it's just an absolute blast.
That's great. Both of you have really broad experience in your careers. What motivates you to work with this audience? Why don't we start with you, Mark?
Yeah. So, excuse me. So thinking to the, I assume your question is sort of about what we can do with the pro bono programs in this particular audience. Very interested in trying to help spark the economic area in our region. You know, we need more jobs. We need to, particularly in the Gulf South, kind of stop what we call the brain drain. We've got a lot of people that are very excited to be part of our community and very eager to build businesses here, but sometimes there's just not enough of an infrastructure to do that. And then we'll lose them to bigger cities and for opportunities elsewhere. And if we can remove some of the barriers to protecting the intellectual property through these programs, they'll put their roots down here in New Orleans or along the Gulf South, and hopefully chip away at the problems that we have retaining people. You know, they create jobs and they just make us a stronger region and then country overall. So it's something that really motivates us to put time and give back. And then I know we'll talk about this a little bit later, but you know, the attorney time for filing a patent application can be pretty pricey. So if we remove that barrier, that's one thing that we can do on our end to just really chip away and try to get people involved. And then when they know they have support here from their friends and their neighbors, they're more likely to stay and be part of our team.
Great, thank you. What about you, Paul?
Yeah, as mentioned, I have a lot of experience in big law, and those projects were fine. They were nice to work on. They gave me a broad range of experiences across a lot of technological fields. But I think there's sort of almost a philosophical difference between what I was working on in big law and the types of inventors we get in our pro bono program here. And it's just a question of, okay, why am I getting this patent? Is it because my company offers me a $3,000 bonus, so I just came up with something? Is it because the company, you know, a large company wants another number in an Excel sheet somewhere saying we have this many patents for this technological area? You know, that's fine. There's legitimate reasons to want to do that. There's defensive patents and all like that. But I was actually a volunteer for the program I'm a director of right now for many years. And these were always the funnest projects to work on. They were somebody's baby. They were someone's invention they've been working on for a long time. They're passionate about it. It's just a very different thing from the corporate type of patents to the sort of individual inventors looking to build a business that we get with the pro bono program. And it's just so much fun to work with these inventors. So I wanted to do more of it. So I made the move to become the director of the pro bono program I was volunteering for.
That sounds really motivating, and I know I feel similar motivation when I work with inventors as well. Paul, can you provide an overview of the program that you were just describing? What are its main goals and services?
Yeah, so we're basically partnered with the Patent Office, the USPTO. I'm one of 20 programs across the country, and some of them are a single state. Like, for example, the Chicago-Kent Patent Hub only serves the state of Illinois. Some of them cover several states, but between all 20 programs, all 50 states are covered by this program. And importantly, we don't offer legal advice. We're not going to tell someone that their invention is patentable or not. What we do is have sort of matchmaking services between the under-resourced inventors and our network of attorneys who are willing to offer their services pro bono. And we do some vetting of the inventions. So as I said, we won't tell you if your invention is patentable, but we do have to have our own sort of threshold of patentability about who we accept into the program. We can't waste our attorney time. That's a limited resource. And we also don't want to waste the time of the inventors. The services are provided pro bono, which is very significant. It could be $10,000 to $15,000 worth of attorney time that you're getting pro bono. But the inventor, the inventor does have some skin in the game still. They still have to pay the fees to the patent office. There might be draftsperson fees for creating figures. I always find it funny. We have one law firm that always reports their hours, their pro bono hours to us, and they always make sure to also give us the dollar number figure of what that number of hours represents. And
I want to make sure that you know.
Yeah, and admittedly, it is quite impressive every single time. But yeah, that's our partnership with the USPTO. We're independent entities. We each have our own different rules, slight variations on who gets accepted into the program. But it's all sort of this one goal in partnership with the Patent Office to get more of these resources to the inventors who need them.
Great. And how about you, Mark? Can you give us an overview of your program and what you offer?
Absolutely, and just thinking about Paul's comment about the bill that wasn't an actual bill, but more of just a recap. We did have one firm that just kind of sent us one, and I did have some heart palpitations knowing that wasn't real, but still seeing that number. So it's nice to know that programs like Paul's and ours can remove that from as a barrier for inventors and make sure that we're accessible. So our program is part of the United States Patent and Trademark Office's Patent Pro Bono Program. So we are partnered with the Patent Office, and like Paul's, and we cover 3 states: Louisiana, and now as of May 1st, Mississippi and Alabama. So we started from scratch in 2018, building the program, and went live in 2019. So the ELVA project is the name of our organization. And then we kind of sub-brand the Patent Pro Bono program as Gulf South Invents. It used to be Louisiana Invents, but we got voluntold to take over a couple more states. It sounds like we've got a huge amount on our plate, and we're very happy to serve. But I would assume that the population of the 3 states total is probably smaller than the north side of Chicago. So it's a little bit lower. But what we do is, we receive applications to our program, and there's a couple of prerequisites that we ask our inventors to do. There's a little skin in the game to make sure that the inventors showing up with a little bit of homework that's been done. We like a good, solid description of the invention. It needs to be a little well-baked. We got to have not so much of a wish list, but kind of a full-throated invention. It doesn't have to be finished. It doesn't have to be a full draft of the patent application, but we want to be able to explain it so our attorneys can understand what's going on and then do their job. And then you go through an online application to our program. That's not the patent application, and that includes reviewing the USPTO's 1 hour presentation or so on some background on the process to make sure that you're familiar with it, and you got to check a box. You can also listen to me give a presentation, and I can drone on for quite a while, so the online version might be a little bit more efficient. And then there's a little application fee to help us with some of our services. It's not a lot, but also charging a little bit can assist us with moving forward. And then what that does is and before I go into the next step, we ask the inventors to perform a little bit of a prior art search. And we'd like the inventor to go out into the wild and see if there are any inventions that are out there that may be similar or close, that may be published patent applications or issued patents or anything else that may have been disclosed to the public that may be evidence that their invention is already known. Because a lot of times, the inventor may be in a space working and not seen something in use or in practice, but an invention is a good idea, but it may have already been written about and disclosed, but never commercialized. And that happens to about 90 to 95% of patents, if not more. So we like to do some background information before that, because we got to be very careful with our volunteer attorneys' time, and we want to make sure that applications that get sent ultimately to an attorney to match are viable. Not that they're not a good invention or even a great invention, but that they can go through the patent process and have a chance of becoming an issued patent.
Great. You touched on this a little bit, but what inventors are good candidates for your programs, and how do folks know when they're ready to reach out to you? And one thing I picked up on what you were saying, Mark, is how complete, how ready does the invention need to be able to start engaging with you?
You got to be able to explain how it works and how you're going to be able to use it. You got to connect the dots from the start to the finish. An idea of what you want to do, and thinking about how something would be great if we could do this, that's not ripe enough. Without getting into a super concrete example, you just want to think about if you're able to get to the point where somebody, whether it's you or whether it's your patent attorney, could write enough about your invention where if somebody that's in this particular field later could read what we wrote and then go back and make it themselves later. So in patent terms, that's called enablement. So what we're doing is we're writing a roadmap so that when the patent expires later, they can say, oh, I know how to do this. So a good example is a prescription drug. At one point, all of those drugs before they had the CVS brand were probably subject to a patent. So the white label manufacturer needs to be able to go say, I can put all these ingredients together and I can come up with CVS brand Advil and call it ibuprofen and be done with it. So it just needs to be able to say that. So if you're at that point, that's when you're ready to come see us. And we'll talk to you and tell you, hey, come back to me when you got it a little bit more ready. We're not going to slam the door in your face. That's the point where you should be on the inventor side. And then it's our job to write about it in a way where it becomes the roadmap. So the attorney has a big role in this to get it ready, but you just need to be from the inventor side at a point where you can explain the instructions and explain how to make it work.
Great.
Paul, you have some thoughts there?
I pretty much agree with everything Mark said. I tell this to inventors all the time. An idea, even a great idea, is not an invention. You have to have idea plus implementation. You have to be able to make it, have a good idea of how it works. It doesn't mean you have to have a prototype on your desk or anything, but you have to be far enough along that you could probably build a prototype if you had to. Even if you had to bring in an engineer or something to do some of the nitty-gritty stuff, you have enough information there. And yeah, it's once you engage with our program, it's once you have your foot in the door, we will engage with you as much as you want. Even if you're rejected on existing art out there for your project, well, first of all, if we give you some prior art and say, hey, it's already been done out there, then if we miss something, tell us, like, hey, this is a really important feature and you actually didn't find anything about that. Definitely let us know. But once you have your foot in the door, it's a back and forth. I've continued to work on my invention. I added a couple of features. Can you reevaluate at this point? So we're willing to engage with inventors, as long as they want to engage with us if they're continuing to work on a project or an invention.
Great. Oh, go ahead.
I was just gonna to make sure to elaborate on one thing that Paul said, because it's so good. One of the things that it's important for us to help inventors understand, and for us to make sure that inventors can internalize and then sort of take away from a meeting with one of the attorneys is, it would be amazing if you were the first to invent anything in an area. But a lot of times there are other things that are going to be similar. So you may not own the entire freeway and all the lanes, but we may be able to carve out a lane for you to still drive on. And the attorney is going to have to sometimes help you identify a narrower spot for you to drive. And as Paul is talking about, maybe there are some features there that could get you something patentable, but it's not going to be everything that you wanted. But you may have something that's going to be enough to get you through the patent office, and that may be something that's going to give you a commercial edge. So a lot of times inventors can get frustrated when they see what they think is the scope of their rights narrowing a touch, but the reality is we can't control what has come from other inventors before us.
I think that's a great point. I think a lot of inventors forget that that incremental progress is also extremely patentable. And if you have that, that can be worth patenting as well versus something that's completely brand new. Do you have, is there criteria that your programs have that inventors have to meet in terms of means testing or something like that?
Yeah, the Patent Office basically imposes two requirements on us to enforce. One is income eligibility requirements, and that can vary from program to program. Through congressional action, we can go up to 400% of the federal poverty guidelines. So our program actually does the 400%. I know other programs aren't quite there yet. They might be at 300% of the federal guidelines or 200%. So that does vary from program to program. The other restriction is what they call the knowledge requirement, which Mark touched on earlier. You either have to have watched the video from the Patent Office that teaches you a little bit about patents, and it makes you answer some questions, and you get a little certificate at the end, or you have to have demonstrated knowledge in some other way, like having already filed a provisional patent application on your own. But that's basically the only two requirements, aside from actually having an invention, of course, which we talk about when we have the inventor meeting.
Great. So many inventors are understandably concerned about the cost of obtaining a patent. You mentioned a little bit about your invoices that are coming in. How does working with your programs mitigate those costs?
I can go ahead and just touch on that a little bit. Yeah. So as Paul mentioned, we may ask for a little assistance from the inventors for drawings, because for a non-provisional patent application, you need formal figures, which are, if you're familiar with those cool patent drawings, you can kind of see them around our background now. They're usually black and white, but the blue ones are really cool. And then the filing fee. Other than that, the entire idea behind these programs is to eliminate billable time from attorneys. So what could have been a couple hundred hours for 10 to 20 hours of attorney time just goes away. So, we're thinking, a couple $100 for drawings, and the filing fee for what's called a micro entity, which you would have to qualify for to be in this program, which I believe is less than $284,000 a year. I may have that number a little bit off, but if you're making more than that, you're definitely not going to qualify for our program. The filing fee is $364 for a non-provisional application. So those two numbers together are definitely nothing to sneeze at, and are meaningful, but that's going to remove thousands and thousands of dollars of attorney time. So, and you'd have lead time of knowing what those two costs are, and the filing fee is fixed. That's generally not going to change, and it's actually gone down, which is one of the least American things I've heard of in a long time. So those are the two costs that you could expect, and then every program may have an application fee or may not. Ours might be around $55. I don't handle that particular aspect of something like that. But so, the costs I outlined, and that Paul and I have been talking about, they're real. It's real money, but we're not talking, between $3, $5, $10, $15, $20,000. So that's just gone. And hopefully, hopefully you don't have to duke it out with the patent office to try to push it through, and they're getting rejections, and hopefully you get volunteer attorneys that go with you the whole way through. I've worked with a couple of clients where I've handled rejections and we've gotten patents, and then you've got a piece of intangible property that you're holding your patent certificate. And I think my hand was off screen, but that's how you hold your patent, I believe. And you've got something that you can monetize, and you make your investment back.
Great. What does an inventor need to do to get the most out of your programs? Paul, why don't we start with you?
Sure. I think it's much of just what we covered before. Just actually have an invention to start out with. So that idea plus the implementation. So we always require, if you don't tell us that you at least have a figure to talk about during our meeting, then we're just not going to schedule the meeting. We have to have something to talk about. The more detailed, the better. The further along you are in actually being able to create a prototype. Again, it's not a requirement for us or the patent office that a prototype be created. But the further along you are in that process, the more detail you have on how the individual features work is very helpful. Not just in convincing us that you have an invention, but it's going to make it harder for us to find that prior art out there. If you have details and specifics about how certain components work, then it's not just the feature, it's not just the function we have to find, it's the function done in that particular way we have to find. So that makes it harder for us to find prior art. It makes it harder for us to reject you from our program. And if you do get matched with an attorney, it makes it much easier for the attorney to put all those details into the patent application, which you absolutely want. The more details, the more ways you can do things, the more you can discuss your features in the patent application, the stronger it is. The attorney will be happier because they know they're submitting a strong application that they won't have to argue with the examiner as much about. And the inventor will be happier because they have a much stronger patent application. Anything to add to that, Mark?
Yeah, I think so. And just a couple of things come to mind. We've talked a lot about the substance today, but also just thinking about communication. Definitely, work with the attorneys. Remember that they're on your side, and their goal is to help you get something for you, and they're donating their time. We were just at the patent office for our conference for the conference for this program, and some of the feedback we got from some of the other programs is, inventors, they get really excited. Like, this is a passion project for them, and they want to hear and they want to go as quickly as possible. The volunteer attorneys sometimes have other fires to put out, and it can take a second to get back to them. So just, be a little patient for that. They value your case. And the other thing is the patent office does not go quickly. We can use a program that expedites the process called the first time filer program. That can still take up to 6 to 8 months to hear from them. So you're gonna, for lack of a better analogy, and hopefully I don't get in trouble, but you're just pulling your ticket and sitting down and you wait. There's just a lot of really good ideas in this country, and there's a big line. So you do have to wait. So just understanding that you're going to hear back when you hear back, and hopefully we get good news. And the other thing too is just kind of cooperating with the attorney when they may be delivering some news to you that they don't want to, whether it's on the front end or after they've heard back from the patent office. I hate to use this term, but the worst part of our job is killing dreams. We don't want to do that. We never want to do that. But sometimes a really good idea has already been thought of and you just didn't hear about it before. Sometimes going back to the drawing board or tweaking an invention is a great step. But trying to know that everybody is trying to collaborate and move towards the same goal is just really helpful when we come up to a roadblock. And the patent examiners are not there to prevent you from getting a patent. They are there to make sure that you don't get rights that you're not entitled to. And if you are entitled to a patent, they will give it to you, or they'll identify a spot that maybe you should get one, but not the rest of it. So understanding that kind of process and then sort of going with the flow as best we can. And if there's arguments to be made, patent examiners can be wrong. I'm going to be diplomatic there, but we will push back. But sometimes bad news happens, and just making sure to understand that can be part of this process, I think is really helpful to kind of internalize.
Yeah, I think that's a great point. I think a lot of folks, who are not familiar with this whole process hear of patent examiners and think that they're out to get them. But it sounds like it's a much more collaborative relationship in terms of figuring out what the inventor is entitled to.
Absolutely.
Can you share a success story or examples of some inventors who have successfully navigated the patent process with the help of your programs? Why don't we start with you, Paul?
Yeah, I actually wish I got a little more direct feedback in this sort of thing, because we don't really get real-time feedback in where the inventors are in the process unless we go out and do surveys and ask. And we did do that a couple of years ago. So I have a few examples that are a little bit older, but we asked, okay, did you successfully get a patent, first of all, and are you using it in a commercial manner, and is it a success? And we had several responses that were positive and a yes there. As far as granted patents go, our program is closing in on 100 granted patents at this point.
Wow.
But like I said, these are what we actually got feedback on. So there are just a few examples. There was a briefcase type device that actually unfolded in a specific way to be able to hold your iPads, your electronic devices. So very specific mechanism of unfolding and then standing up to be able to hold your electronics devices. There was a beverage distribution device. So for like parties, you have like a larger container of liquid, and then this device enabled you to evenly distribute to multiple cups at the same time, the same beverage with the same cup getting the same amount of liquid every time you use it. We had a hair care device that's specific to dreadlocks. Actually, dreadlocks have like stray hairs and flyaways that can happen. So this actually trimmed those excess hairs specifically on dreadlocks. And our survey came back with a couple of design patents as well. Our program does cover design patents. For anyone who doesn't know, usually when you're talking about a patent, you're talking about a utility patent. Just everyone uses the shorthand patent. Utility patents cover the function of a device. There's another type of patent, design patents, that cover the look or the ornamentation of the device. So they tend to be shorter patents. They're just figures shown from various angles, but you can cover the look of something. So we had a couple of patents that one was a pin and one was a type of furniture that covered the look, and they actually went out. They were able to actually manufacture these products, and they're partially covered by the design patent, giving them some intellectual property protection.
That's great. What about you, Mark?
Yeah, so the story I was going to bring up is a client of mine. He has a really cool invention. It's a type of shipping container house, but it's not one that you would think of where you drop a shipping container down and then start hacking it up and building your house within it. And the idea is for hurricane disasters. And we're right here. So I'm sitting in New Orleans, and we are kind of the poster child for hurricanes, although Florida is not having a good year. So a lot of our thought processes are thinking about, hurricane response. So not only was my client, a beneficiary of the pro bono program, but he's in turn trying to give back, where he's thinking about how to quickly respond to a hurricane. So his idea is very interesting. So you think about a container ship full of shipping containers, and you deliver it to a site that has just been leveled, horribly leveled, and you could drop off shipping containers plot by plot, and then they would be put on a foundation and be permanently built as a part of the house. Now, Paul said something very important, and I think he was making sure to tee me up for this because he knows I'm going to do this. You never need to make a model of your patent or your invention, and that is not required. This is the only time this has ever happened for me, and my client is an artist and builds things, including replicas of bars that he makes music speakers out of. So I actually have a model of the house. So it's pretty cool. So It's got a little shipping container in it. And what you do is you deliver all of the components for the house within the shipping container. You open the door and then you pull them out, and then you build the foundation, or the lower floor right here. You put all the pilings around, and then it's a permanent structure, and then you can kind of customize it any way you want as a regular house, and the shipping container stays there forever. So you have these lining up the block with a very rigid foundation. And we got 2 patents on the method of building construction, and now we have a 3rd one pending for the building itself. So we are trying to protect this as many ways as possible to try to get him a really strong foundation for his business. No pun intended. That was completely accidental. And he's able to use this as part of his grant writing to ask for either funds or assistance with launching the business to get this off the ground. And I think as we get more and more hurricanes and stronger hurricanes, this is going to start to provide a really significant impact. You think about FEMA trailers getting dispersed to properties and they go bad just with time or logistics. This is not going away. So I was very excited to work on this invention and hopefully keep those going. And do not think you need to build a model for your patent attorney. That's just a one-off. So just want to drive that down.
You have a special client who does other sorts of fabrication, and you lucked out.
He's always building.
That's great.
I love it. So I'm hopping in here, crew. We've got a couple of questions from the audience. This one comes from Jose Cano, and I feel like you've already covered it, but just in case there's anything that you'd like to include, I'll just read it off, and whoever wants to take a stab at it, please do. Jose says he's an independent Miami-based inventor. It's more than 2 years that he's been trying to get a law clinic school anywhere in the U.S. to process a PPA, but no luck so far. Accordingly to USPTO standards, he has to qualify for micro-entity status. Is there a solution that you guys can recommend?
So it seems like there's 2 parts to that question. One is micro-entity status. That's generally pretty easy. It's based on the number of non-provisional applications you've filed before, and then the amount of your income. So if you're below that income number, you should have that box checked. Otherwise, the program is typically based on where you're located. Sometimes they're a little backlogged. So, reaching out to the group that covers Florida, I forget which one they are offhand, but if you go to the USPTO's website and you navigate to Inventor Resources, I forget exactly where the link is offhand, and I apologize for that, but there's a way to get to the group that covers Florida, and then you can just reach out to them. And that's where I would start. I think you would need to go to that one specifically. Unfortunately, our program would only take for our 3 states. Just that's kind of the way that we're structured. But candidly, sometimes there can be a backlog. So it is a little tough just because we're working on volunteer hours.
Yeah, probably the best way to find your program, I would say, is just Google USPTO Pro Bono. That's probably the fastest way to find that webpage. I always tell people to find us, Google Chicago Kent Patent Hub, as opposed to trying to provide some sort of link. That's probably the fastest way to find us. The other thing that I got from that question is that they might already have a provisional application from 2 years ago. So I just wanted to highlight that. And unfortunately, if you do file a provisional application, you do have to file your actual application within a year of that provisional application. So it won't hurt you, but it won't help you either to have that provisional application filed.
Got it.
Speaking in general, definitely no legal advice.
We have a very large asterisk behind our names.
Very large asterisk, very noted. Okay, so then having said that, we've talked a lot about the pro bono programs that the both of you offer, that your firms offer. One question is, where can they find info for eligibility and how to sign up? I imagine just Google again, or what's your best bet?
Yeah, like I mentioned, there is some variation between the programs. So starting at the USPTO webpage and finding your particular state, they will link you to your particular program. And then hopefully, like our program, it's right up front about what the eligibility requirements are.
Yeah, same with us. Just Google Ella Project or the Ella Project. I think we're ellanola.org, ELLA. And then it would just be resources for inventors. And it's all right there on the front page.
Perfect. And we'll make a note of that for all of the attendees to at least put it in the show notes so that way you can grab that as well.
Thank you.
Having said that, we do have another question. This one is specifically for Mark. Mark, are there any pros or cons for the applicants to do their own prior art search?
Yes. So first of all, that's something that we would ask you to do as part of our application. Every program has a little bit of a different application, but we have some swapping of applications within the programs themselves. So you may see similars across the applications. So doing a prior art search yourself is very helpful because it helps you understand the lay of the land. You'll see what else is out there, see who else is invented in this space, and what kind of relevant inventions may provide what's prior art to you, or something that could even anticipate your invention, which means that your invention, either as a whole or in part, is already known. Sometimes, if you get one that's what we call a direct hit, that can be bad news. But if you get one or two or even three that are kind of close together, that in combination might, as a whole, block your invention, you can start to see how you could chip away or why they may not work together, and kind of anticipate yourself how you could push back. And another way to think about doing a prior art search is you learn about the patent process, what one that looks like on the back end that's been granted, what they include, and how to write a patent application so you can help your attorney with more information that you may not have thought about. One of the things that we encounter with inventors, and I encounter that in my private practice as well as pro bono, and then actually when I'm teaching my academic classes, is everything is up here always, but we got to get it on the paper. So when you see what's actually in a written disclosure on a patent, you're like, oh, I actually have to say that out loud. And that can help a lot too. So that's a kind of a tangential benefit, but the best benefit for a prior art search, that A, you would have to do it for the Ella project, and B, that if you do find something that's very, very relevant, that will save you time and money by not going down a path where there could ultimately be something that would block you, and you either need to kind of maybe think about a new project or a pivot.
That's very helpful. I like when you said about putting your thoughts onto paper Reminds me of that saying of our thoughts become our words and our words become actions.
I love that.
Paul, we have a question for you. And the question is, would you have a sense about how many applicants access the PPB program? Is there an information awareness gap among applicants about the program? OTOH, is there a wait list since there are more applicants than available volunteer attorneys?
I'm afraid I'm only familiar with my own little fiefdom here, so I don't have any numbers on the overall applicants. The Patent Office probably does have access to that information. Like can speak for Illinois. I would say we average about 100 applications per year. Roughly half of those will go on to get matched with an attorney. We might be a little bit more stringent in that regard than some of the other programs. We do a prior art search on each applicant that comes in, and then, as I mentioned before, we do have our own threshold of patentability we have to meet. So we want to make sure that the applications that get passed on to our attorneys are viable and quite strong. So our numbers might be a little bit lower there. As far as wait lists, that's just ebbs and flows, I think, with the various organizations. A lot of them, like I do have a little bit of a backlog right now with inventors that have passed our threshold but are waiting for attorneys to pick them up. As far for us, it is unfortunately not a first in, first out type process. If you get accepted into our program, you get put into a pool of available projects, and then our volunteer attorneys are able to pick and choose from those projects as they see things that interest them or they have time. So you could get accepted into our program and get lucky and get matched with an attorney almost immediately, or it might be some number of months. And then that's unfortunate, but as Mark mentioned, the entire process is slow, so maybe it's not horrible if you get used to the slowness of the process. But of course, we cross our fingers and hope that everyone gets matched quickly.
Got it. Thank you. And here's another question for Mark. Can you mention a few methods to find relevant prior art?
Absolutely. So my favorite one is patents.google.com. I think that is probably the most effective search engine. And one of the things I like about it the most is it gives you a preview of what the patent looks like. So right there when you get your search window, you just type it in. Another one is freepatentsonline.com. That is great. That one you have to do, I think, 2 clicks to get to the PDF of the patent. And for some of us, that is just simply onerous. But it's an incredibly effective search engine. So those 2 are my favorites. Also just regular Google search. Type it in and see what comes up. And especially if it's more of a commercial product rather than, a pharmaceutical or something that would be, used in like a chemical plant or something that's, very, very unique. Once you hit Google, you can also hit images, and an image search result, you can start seeing something that may look like your invention or be relevant. And then the Patent Office has a search engine that can take a little bit to get used to. The nice thing about the Patent Office is that's the one that's the most up to date. Sometimes Google can take a few minutes to populate its stuff once the Patent Office has released it. So patents come out on Tuesdays. So if you're searching on a Tuesday, you might not have everything up to date. The likelihood that something exactly on point comes out that day, probably low, but it's probably worth noting. So those are where I would look, and kind of in that order.
Very helpful. Thank you. And again, to all the attendees, when it comes to all the links, we'll share those as well. Sorry, Paul, what were you saying?
I was going to say, and that touches on a misconception I get sometimes, is that prior art has to be a patent application. And unfortunately, everything counts as prior art. Websites, if the product is offered for sale on Amazon, all that is also prior art. So just to make sure we understand that part.
I'm going to add one more nugget, although I don't want anyone to feel like this is in any way something that would be a prerequisite or something that you need to pay for. But a lot of law firms, including ours, work with search vendors, and you can hire a team of search specialists for anywhere from a few $100s if they're offshore to several thousands if they're considered sort of premium vendors in the United States. and they will go and do searches for you and come back. And they're specialized to use all the search resources. So that's also an option depending on resources and funding versus doing yourself. But that's not something we would ever expect from somebody that is in this program, but it's just one more resource that's worth noting. There is a set of vendors that do that.
Very helpful. Here's another question that we have from the audience, and this goes to all of you. Do all law offices participating in the pro bono program use the same onboarding process? Is it pretty standardized, or is it customized per program?
I would say that's up to the individual law firms. Like, we don't really impose any requirements on them. I can guarantee you that there will almost always be an engagement letter detailing what your duties are, what the law office's duties are. They'll expect you to sign that engagement letter before they take you on as a pro bono client. But that is, and we have some templates we provide to law firms, but I think they almost universally don't use ours. They have their own templates and engagement letters that they already use. Every single law firm will also do what's called a conflicts check. In my experience with the inventors to our program, that almost always passes, but law firms have an obligation and ethical duty not to take on clients that are counter to some other client they have on, or cover subject areas that would be detrimental to other clients they already have. So you will always go through a conflicts check, which will probably pass when you get introduced to a law firm and they're looking into whether they can take you on as a client.
Very helpful. Another question that we have, this particular attendee lives in Houston, Texas, currently has a provisional patent on their invention. Where can we get similar pro bono services to help in our next phase of full patent?
TALA, Texas Accountant and Lawyers for the Arts. They're based in Austin. TALA, I do not know their website, but that is the program that actually used to handle Louisiana before we took over, and they run the pro bono program for Texas.
That felt like a Jeopardy moment. I'll take Tala for 500, please. Great.
And it's definitely not an impediment to have a provisional application already. I think our attorneys love to work with the provisional applications, turning them into non-provisional applications, unless you're close to that 1-year deadline, and then we're going to tell you, we're probably not going to meet this deadline. If
I would call them right now.
Filing date, yeah. If you want that earlier filing date to count, you might have to do something yourself. But other than that, they love to see provisional applications.
Okay, got it. Here's one last question that we have. Can someone be reinstated in the pro bono program if their income status has changed?
For our program, at least, we say you have an obligation to report to us if your status has changed. So if you're applying to us, then we expect you to be, and it's the current year's income, which we understand is up in the air. So most people estimate it based on previous year's income. It's just a good faith effort to let us know whether you qualify or not. If at some point you get disqualified because your income goes up, it kind of just depends on where you are in the process. If you already matched with an attorney and they've 90% finished your project, I can't imagine they wouldn't just go ahead and finish the project for you. Just be aware that that doesn't work that way for the patent office. As soon as you're disqualified for microentity status, that's how you have to file. You'll have to file as a small entity instead. But as far as we're concerned, it's just in the instant moment, do you qualify for the program or not? And if in the future you qualify again and you want to resubmit a new patent application or a new invention idea for our program, then go ahead. You are now qualified again to enter into our program.
Great. Okay, one last question. Ooh, they squeezed that one right in. They're like, ooh, it's Q&A time. All right, so this one is, besides the joy of helping out budding inventors, What other incentives can motivate attorneys to participate in the PPB program? CLE credits, for instance?
This will be a little bit cynical sounding, but I find the greatest motivation, especially for our larger law firms, is if they get billable hour credit within their law firm for pro bono projects. So a lot of our volunteer attorneys are in larger law firms because they do have pro bono programs that give them billable hour credits. And it's just very nice as an attorney. You still get credit for your time, but you're working on a project you chose. That's something that interested you.
Good. Okay, great. Well, thank you, Aaron, Paul, and Mark, and to all who attended today. Thank you so much. You learned so much. I know there's a lot of notes that we have to send out. Having said that, we will be sharing a link to the webinar in the next few days, so please join us for our next webinar. The date will be forthcoming, but in that sense, again, thank you, Aaron, Paul, and Mark. You've been absolutely amazing. Thank you so much.
Thank you.
Thank you. It was a pleasure.
Thank you.
And to everyone that joined, again, we will be sharing out a replay of the webinar over the next few days. In the meantime, if you'd like to, you could go ahead and scan this QR code to learn more about the Inventors Patent Academy. Thank you so much.